welcome to another episode of Legal for Tech, the podcast. So, guys, you do recognize my voice. It's always Rosie here, and as you've said many times, this is just for students and young professionals who are very interested in anything that has to do with technology and, yes, its regulation. So today I am joined by my friend and great producer of this podcast. Hi, Giacomo. Great to see you.
Hi, Rosie. Very happy to be here and welcome back from Milan.
Oh, thank you. I'm actually missing the weather. I'm back in Germany. And actually, I have to say, I think someone in this podcast is in a worse situation than me and definitely than you. Great to join you and you to join us on this podcast. Marco Bassini, who's calling us from Tilburg, which is definitely a bit grey today, I'm told.
Thank you both for inviting me. It's a pleasure being here, and good afternoon, everyone.
Good afternoon. I have to say it's a pleasure to finally talk to someone from who's Italian but is an expert like both of us basically. This is Professor Marco Bassini. He's a professor at the University of Tilburg, and today he's here to talk about the European framework, the legal framework that we have been talking about basically on the whole of this podcast. But also, he's a specialist in constitutional law. So. Before we start and we head off with the actual topic of this podcast, tell us something about yourself, Marco. Explain to us why you're here today.
I think I'm here because I have an expertise on digital regulation and what's happening now in the EU in particular concerning some very important technologies such as AI. But my career led me to Tilburg University. I joined Tilburg University in 2023, so 3 years ago. After conducting research in Italy, I got my PhD in constitutional and European law, which was very helpful because it gave me a background on human rights in particular, both from a national and international perspective, to look at what happens in digital technologies and how digital regulation may affect or protect human rights, which is, of course, the core of my research and also something I'm really interested in. So I have been working in Italy for a while at Bocconi University, which is also my alma mater. And then I joined Tilburg University, which is a very nice environment at the Tilburg University Institute for Law, Technology and Society, where I am now assistant professor of fundamental rights and AI, which is quite a combination.
We want immediately to dive deeper into the topics, but first of all, I would like to ask you to, if you could talk a little bit about the article that you wrote, and that is called, if I'm not wrong, Better Lawmaking and Evaluation for the EU Digital Rulebook. If you can tell us a little bit about it, and from there we can.
Yeah, it's an article I co-authored with Maria Teresa Maggiolino and Alexander Storel a few months ago now, I think 1 year almost. And it's basically an article where we try to look at what's happening in the EU lawmaking when it comes in particular to digital law and digital regulation, just because we know that there are a lot of calls for better incorporation of the better regulation principles into EU law. The better regulation principles are very important in respect of the way the EU law is made. And what we were looking at is basically the life cycle, let's say, of regulation in the digital sphere. So we choose to focus on three acts in particular, the DMA, the DSA, and the GDPR, but similar efforts can be definitely reproduced and put into other acts, just to understand what was the mindset of the European Commission in particular at the time they delivered their proposal, and what changed over the legislative process, and what can we suggest the EU lawmakers to do if they want to improve the quality of legislation in EU, in particular in EU digital law, and if compliance with the better regulation principles can be improved, and they want to improve it, of course, because this is an article where we wanted to look, for example, at impact assessment, the way impact assessment were conducted. And of course, after some years, you have the chance to see whether the predictions that they made and the impacts that they were assessing actually are consistent with the state of the art, or maybe something changed, or maybe some costs in terms of compliance, for example, were underestimated or overestimated. This is quite, similar to the effort that we can now put maybe in exploring what's happening with the digital omnibus, because we want to understand it actually. We had some costs to reduce to cuts, and in a certain way to frame and shape your law can help in that perspective. Of course, we have broader goals here, which is the goal of digital competitiveness and fostering this competitiveness, which is, of course, another important aspect we will, I'm pretty sure, talk about now. But yeah, the article was quite interesting experience because it gave us a chance to look back, to look, let's say, also ahead for what's happening and what's in front of us and the new challenges we're facing now in new digital regulation.
Wow, I have to say that the way you described this life cycle definitely reminded me of this series of paintings by Klimt, this kind of idea that the child, then the mother, then the older person. I'm wondering, is the digital omnibus the elderly time of something like the GDPR and in general the digital framework of the European Union, or would you describe it as a different time and age?
I don't know, actually, it's a very tough question because there are different angles from which we can look at the digital omnibus, and of course we can also make some distinctions between the digital omnibus concerning data protection and data law, let's say, and the digital omnibus on AI, where I think there might be some interesting divergences or convergences, let's say, depending on the way you look at them. And I fail to have a clear view of what the digital omnibus is right now because maybe this is part of the nature of omnibus packages. So the fact that they are everything and nothing at the same time. So they basically include many very specific provisions, but they maybe change very important aspects and details, such as the definition and the notion of personal data. So you don't get to understand if it's a new phase, they are opening up new phase in new digital regulation, or maybe they are trying to revise and recalibrate and fine-tune legislation. Maybe in some particular respects, the omnibus plan to be very innovative, while in other domains, this is not. And honestly speaking, looking at certain provisions, I guess sometimes it's a kind of maquillage, so it's just rephrasing some provisions, maybe with unintended consequences. I can exclude that. But in other respects, it might be more innovative. So, honestly speaking, I don't know. I will answer your question also because of the important political and economic goals behind this project. Honestly speaking, we can't read the omnibus and we can't interpret the omnibus without bearing in mind and properly understanding it without bearing in mind which are these goals and the role they play and they played in the lawmaking.
And since you've been kind of hinting to them, let's talk about these roles. Let's talk about this new kind of goal behind the digital omnibus. Is it a new goal in the first place? I'm wondering. And secondly, is this really where we're heading? Is this really the European Union we were looking at and we were waiting for 10 years ago when the GDPR first got passed by the Parliament?
Yeah, let's say that there are very interesting changes in the GDPR, but also in other pieces of legislation. As I said before, it's quite difficult to me, honestly, get a kind of overall assessment and view of the many changes. But I will say that this is a clearly politically driven initiative, which, in my view, makes sense in the end because law is inherently political in the end. So we are always talking about political priorities that may emerge in particular phases. And we know very well that maybe it was Mario Draghi's call Maybe it was even before Letta's report call. But we know that there is a urge for fostering competitiveness in the European digital economy. And we know for sure that because we can definitely notice that in the global scenario, the European digital economy, of course, is not leading, and there are other, of course, jurisdictions, the US and China, but also India and Brazil and some countries where, in respect of technology, there are very interesting developments that might, of course, have an impact also on the European economy. So I understand that now regulators are looking at this goal. Now I will maybe frame in more legal terms what I see now in this process, but just let me say, I think that it makes sense that sometimes regulators change their view. It's not only a matter of changing their agenda, it's a matter of understanding what's going on, understanding that maybe something has to be done, and trying to find some possible solutions. The question, of course, is whether these solutions are compatible both with the way we understand fundamental rights, because as you said, we have a quite clear understanding of what data protection is, for example, in the EU. So now it's a bit puzzling that some very important part of the omnibus are changing maybe this view, this understanding. But at the same time, we also know that the understanding of the data protection has in many ways been driven by the Court of Justice, for example, interpreting it broadly, and it is not an absolute right. So there might be circumstances under which there is a balance, and as I said, lawmakers can change their mind, regulators can change their mind. This means that maybe the balance that they found before can change, can evolve. This is also the reason why we have constitutions and supranational treaties, covenants like the Charter of Fundamental Rights of the EU or the Convention, because we want the balance, for example, between different fundamental rights to not deprive any of this right of their essence. We don't want a right to be, let's say, abusive of others. So we want to preserve, all the rights. But this doesn't mean that fundamental rights are absolute. And of course, there is a separate point we should discuss, which is also a point that I leave to you then later for discussion, whether the omnibus is actually weakening fundamental rights, and particularly in respect of data protection, which is something we can discuss because if we look at the specific provisions, maybe some believe that it's really worrying, and some have a lot of concerns. Others believe that it's not that concerning, and maybe it's a new setting that might be helpful for other to pursue other goals.
Before discussing this thing, you talk about the importance of the Draghi letter report in initiating this digital omnibus. Do you think that also there was a sort of political pressure coming from the other side of the Atlantic, from the Trump administration, and of course from the American digital companies? Or do you think there was a right balance with Europe, where also European companies were pushing for a sort of simplification?
But let's say I can't exclude that in a way this is also the result of a kind of factual assessment that we don't have a European Union-based big tech comparable to the big tech companies that we have in the United States. This is, I think, quite easy to see. And of course, when it comes to lobbying in digital regulation, of course, some pressure, of course, may derive from big tech. But I think that we have to consider two aspects. First of all, we are talking about simplification, and simplification should be something we try to pursue, in particular with respect to small and medium enterprises, which should be the real target. We can discuss, of course, if this is something that the omnibus will achieve, because apparently some of the changes in the GDPR in particular, but also in the AI Act, will be in a way beneficial, most notably for big platforms, big companies. So maybe we should see whether the omnibus will deliver in this particular respect. But the second point that I want to address and highlight is let's take a step back. And you mentioned the political dimension, which is really important here. I think that the point of competitiveness emerged in the political agenda of the EU recently, in particular with respect to digital law. And it's a very important one. And also, as a lawyer, I tend to distinguish this concept from the idea of competition, because if you can translate competitiveness and competition in very different ways in your own language. For example, in Italian, that's very different. Concorrenza versus competitività. So it's very telling what competitiveness is. But it's really difficult to capture it into a very legal notions because there is no legal notion. So maybe it's more innovation, let's say. We can say we want more innovation. And however, this is, another factual assessment because we need to unlock opportunities. We need to unlock growth in the EU. And how do you do so? How do you get to obtain a more business dynamism, for example, uh, reducing, for example, costs, including maybe cost for compliance. So it's also a matter of industrial policy in a way, which is something, of course, I'm not an expert, but I think that, of course, there might be some pressure. There might have been some pressure in a way, and I can't exclude that the urge for competitiveness is something which may derive from the importance on the market of certain companies which are not EU-based per se. But I can see this also, if you think about 10 years ago, 15 years ago, I think the EU managed to set a threshold. When the GDPR came into force, it codified a very important message for non-EU based companies, which already the Court of Justice made in its case law, which is the idea you want to make money out of your business relationship with European residents. That's fine. You want to target them for the sale of goods or for the provision of services or for monitoring their commercial behavior. That's fine. But you have to abide by the EU legal system and you have to comply with the GDPR. So even if you are not based in the EU, but you're taking advantage of digital technology to reach consumers in the EU, for example, then you stick. And I think this is a very important message at the time. So I think that you managed to set the threshold. And also with the AI Act, in a way, we found a way to uh, give the sense of what we mean by data protection and other values that we have when it comes to innovation governance. The point is, have we gone too far in that approach? Have we maybe put some unintended constraints on the EU digital economy? And this is the way I see this. So we need to understand how we can, as I said, unlock opportunities in terms of business and attract investments and make EU digital. Because we shouldn't forget that what makes our life in the EU, in the member states where we live, now a quiet one maybe, but a life we enjoy, and we have business opportunities. We were talking about where we live and what kind of opportunities we have in the job market. We need economic growth. We need, of course, that Europe is performing. And I'm sorry, this may sound a bit business, not very legal, but in the end, this is what makes you competitive. So I am a lawyer, and of course, I'm very sensitive to human rights protection. So I don't want that we trade data protection for more business, just to be clear. That would be very bad. But I'm just wondering whether we can do something in order to preserve a decent level of protection of fundamental rights, which is our DNA, in particular data protection, at the same time becoming a bit more attractive. Because my feeling is that sometimes we are complicating a bit too much the framework and regulation in particular.
Well, and I think all of our listeners will appreciate that, the Charter of Fundamental Rights in the European Union also includes a right to business, a right to property, a right to life. And if we think that, economic wealth is also a way to ensure that life, maybe we need to consider how we balance out those rights. And this is something you were talking about a tiny bit earlier, and because I'm the lawyer in this podcast, because Giacomo studied, as our listeners know, something a bit more to do with politics, I will ask you about the fundamental rights that you mentioned. I think it's very important to maybe just take a step back and remind our listeners, especially the ones that are not based in Europe, how the system of fundamental rights works here. You said the rights are not absolute. They are, in a way, proportional to each other. They have to be balanced out, as you mentioned. And in that light, explain how the right to data protection has been viewed until now, and why something that the Digital Omnibus potentially undermines that right to a threshold and to a level that's absolutely below what we've been saying in the past and up until now.
Yeah, let's say that the right to data protection has been defined by some scholars as the Europe First Amendment, which is quite telling, because in the US, for example, the First Amendment protects freedom of speech in a quite absolute way. It's not absolute, indeed, but it's very broad, and comparably, it's definitely broader than the protection that other rights enjoy under the Bill of Rights in the U.S. Constitution. And this is also, something that shaped the U.S. legal system, because freedom of speech is almost everywhere. Sometimes we might feel that it's too much also. Of course, in Europe, we have a very different view. So we tend to see maybe the US to overestimate freedom of expression. And also recently, the US Supreme Court delivered very important judgments that are discussing, for example, whether online platforms, social network platforms, enjoy themselves free speech rights, which is quite telling. It's the way the debate has been ongoing, and maybe that's also one of the reasons why the US managed to have so many tech companies, and it's also this cultural roots that we can see. But in Europe, we have let's say, a slightly different approach, in the sense that, as I said before, the idea that, except for human dignity, of course, fundamental rights generally do not enjoy absolute protection, and there might be circumstances under which lawmakers in particular have to strike a balance between competing rights. Sometimes we need to limit individual personal freedom because we need to protect people from possible threats to public order. So if you commit a crime, you will definitely face jail, and imprisonment is a deprivation of your personal liberty, but is something that's for the sake of collective safety, let's say. So it's an example of the way we may balance different expectations. And this is also something we see in Europe in respect of the right to data protection, which is, of course, a right that we understand in very broad terms, also because of the approach of the Court of Justice of the European Union, that I will say starting, I would say 10 years ago, 12 years ago, with maybe one of the most landmark cases, Google Spain, released many judgments where it's valued that rights, and I would say operationalized in a very broad way the application of the right to data protection in the digital field in particular. There are many judgments. We can also recall, for example, the data retention saga, which is a very important series of judgments delivered on the retention of personal data. And we have other important judgments regarding also the relationship with the US legal system regarding the transfer to a country, so countries that are outside the union, so they are not subject to the GDPR, and accordingly protect that right in a different way with a different degree of protection. So what do we do under these circumstances? So let's say that maybe also the interpretation of data protection has been driven by the Court of Justice. And this is also, in a way, compatible with the idea that it's up to lawmakers to balance rights, and it's up to courts to determine whether that balance is reasonable. And does not, for example, disproportionately affect competing rights and does not deprive other rights of their essence. This is something that we can find, for example, in Article 52 of the Charter of Fundamental Rights of the Union. It's very clear. So you can't, let's say, protect a right and totally destroy the essence of another competing right. So let's say that the EU has a very huge consideration of the right to data protection. Then I come to the provocative question, because you asked me about the digital omnibus. Too much, because I'm feeling that sometimes when we are commenting, as scholars in particular, maybe sometimes also activists, this changes, and at least these proposals and initiatives, there is this idea that the US are more or less stuck in this free speech exceptionalism. So they see free speech everywhere. And maybe we see data protection everywhere. I don't want to say that we have too much protection, because of course that will sound paradoxical. I think it's a very important achievement and a very important accomplishment that the courts managed to reach. And I am of course very supportive of the right to data protection. But as you said before, it's a matter of balancing. No man is an island, and no right is it's absolute in terms of protection. So maybe there are uh, ages where we need to revisit some choices made previously. And as I said before, maybe now we live in an age where we feel that we need to change a bit the balance between, you mentioned freedom to conduct business, it's another fundamental right. But let's say, generally speaking, we need to do something because we need to promote economic growth. And this would be the way, maybe. Of course, I understand that it's concerning from a data protection perspective. And just to mention a couple of points, I understand that there are concerns about the notion of personal data that might change, but apparently there is no agreement, there is no consensus at EU level, and the co-legislators are already trying to push back that idea from the proposal that the Commission advanced at the time. So it seems that maybe there will be no change in that particular perspective. And I understand that when you change the definition and the notion of personal data, narrowing down the scope of that notion may result in maybe in some approaches where companies are trying to leverage a bit, that change. So they try to say that this is not personal data, so they don't need to comply with the GDPR in respect to some particular activities. But maybe this is also the essence of the accountability principle in the end, which is the core pillar of the GDPR. I understand that also other aspects might be challenging, but honestly speaking, I don't see anything right now which is depriving the essence of the right to data protection in the omnibus. I see definitely many aspects that combine, for example, with this possible change in the definition and the notion of personal data, may give this overall idea that we are weakening a bit the protections. But once again, why are we doing so, and which are the other priorities that are emerging in this age?
I found your point absolutely fascinating, and it makes a lot of sense the way you explained it. You'd forgive me if I add a little kind of maybe another color to this conversation. I always find very interesting how at an academic level, the protection of personal data that has been achieved through the GDPR and all other regulations, because it's not just the GDPR, is always described as something that kind of promotes the right to data protection. That is also a fundamental right, as you said, maybe something in some way, as you said, maybe it has given it an overruling importance. On the other hand, though, coming from the litigation side, if you ask many lawyers, they would tell you that the GDPR hasn't been technically enforced yet. from a remedial point of view. So if we look at the actual allocation of damages for violations of the GDPR, I believe currently the cases are very, very scarce. They haven't even been confirmed yet because they are looking for appeal. Even the case before the CJU is soon to go to appeal by none other than the Commission. So I wonder, is the regulation too strong and the enforcement too weak, or would you say maybe the digital omnibus will bring that balance back? Maybe there will be more litigation and less prior and potentially useless enforcement.
Yeah, I believe that the regulation is very strong, but the enforcement is still quite weak, and this is also a quite general problem that we experience in EU digital law. If there are interesting researchers concerning, for example, the combination of various acts in new law, what you can see under the DSA, what you can see under the DMA, the AI Act, and the GDPR, for example. And it seems that on one hand, there is a problem of enforcement, so making enforcement effective and making these provisions, applied and enforce themselves. But the other problem is perhaps the lack of coordination between different areas, and sometimes it's very difficult to understand what can we do under EU digital law, because there are so many acts. That's also the feeling that maybe I wouldn't say we need a unique channel to enforce our rights, but there is a lot of confusion. So also, the authorities in charge of the enforcement are different authorities. Sometimes you have an European authority, sometimes you have member states authorities. For some particular aspects, you rely on national authorities. For others, you rely on European authorities. Now we got this news that, for example, you can go before the Court of Justice in certain circumstances if you want to appeal against decisions and that is an interesting advancement. But once again, you get to that through case law in a way, and so I feel that we are still missing a unifying vision. And this is a problem that I wouldn't limit to data protection, but I would just consider as part of a bigger issue. But this is also something I'm not part of the Brussels bubble, even if I live very close to Brussels, and I attend some meetings, and I'm also joining some think tank in Brussels. And but what I can see, I think it's a huge problem that sometimes there are different branches, particularly, I guess, in some of the institutions that are not talking each other. So there is not just a lack of common language, but each branch is following its own business. It's minding just about its own business, and this doesn't make it easy to get to this unifying vision and kind of holistic perspective that we are trying to. So I don't think the omnibus will change that much from that perspective. I know that there are concerns regarding the possible limitations on the right to access under our and the and the fact that if there is a request which is considered abusive, then the controller may decline the request. And I think that there is a nice reasoning by the DPP and the BVS in their joint opinion, where they say we need to be mindful that abusive is something we may define better, and we need to understand better just because there are a lot of circumstances where individuals are not just exercising their data subject rights, and particularly the right to access and right to obtain information under data protection justifications, but also for the exercise of other fundamental for protecting free speech, for example. So sometimes you need to want to know something. So I think that sometimes the omnibus may provide some possible solutions, but it's still far, in my view, from solving this big problem that we have in new digital law.
Talking about coordination, that you mentioned, there is a a problem of coordination in the enforcement of these digital laws. What do you think are the greatest challenge in coordinating, for example, DSA, DMA, and the GDPR, the three of the major digital laws that are now in force?
But I think the problem is to make sure that what we see from one of the three perspectives, let's say, is equally assessed and relevant to the extent it might be relevant also from the other branches. So, for example, we know from the Court of Justice that for data practices relevant under the GDPR may also be relevant from a competition law perspective under the DMA. So this is a very interesting point, a very interesting development, which is also, an aspect where when you are advising someone as a lawyer, I'm thinking about that, or I'm thinking about an academic that is trying to lecture students about what they should think about when they are lawyers in their future, in their professional future. I think that it's difficult to tell them, okay, this is the right way to look at these problems from this variety of perspectives that you might have, because you know that a given aspect may be relevant from various perspectives. And this is also maybe a problem of the way we build expertise, because now we have people very expert in content moderation. Then you have the people very expert on the GDPR. Then you have people expert on competition law. And each of them, for example, I'm more familiar with the DSA and the GDPR. I'm not a competition lawyer. So, for example, I'm less familiar with the DMA, but I know that there are very interesting provisions under Article 5, Paragraph 2, for example. And I try to figure out what's going to happen and what kind of, as you said, problems may arise, not only in compliance, but as you said, from the perspective of individuals, users, consumers, whatever the jacket they wear, whatever the clothes they wear. This is I think the big problem, because we can't ignore that it seems that these acts are basically speaking their own language. And also, what I found quite interesting is that, for example, I recently studied the interaction between the DSA and the AI Act. But many times, new legislation coming into force is generally very supportive and also a bit shy in delving into what previous acts already said. For example, it seems that there is this common language. These provisions will apply without prejudice to previous acts. And it seems that everything now is coming up in digital law will apply without prejudice to the GDPR, which is, of course, something that we are happy to hear, because this means that they are not changing the GDPR. If we think that the GDPR is a good piece of legislation, then it's fine. But we might consider sometimes the need to, for example, the AI Act, of course, contains some provisions which are relevant from a data protection perspective, and maybe something now we see something, for example, concerning the legal grounds and the legitimate basis for processing data in the training or on the development of the operation. We see some provisions that are trying to bridge that gap. Why don't we address the gap directly when we are legislating on that particular domain? And similarly, for example, I'm working, just to mention another example that maybe is not so relevant for today's conversation, but I'm working on the intersection between the AI Act and the DSA. There are recitals that are quite clear in saying that if you are developing or deploying an AI system or model, and that model or system is integrated into a digital service under the DSA, then the DSA will apply. Fine. But it seems that this recital just suggests that the same risk governance framework is fine. So if you comply with the DSA, then you are presumed to be complying with the AI Act as well. But what about, for example, content moderation, which is something I have worked on? What about the generative AI systems? What about, so I mean, sometimes this is my own feeling. Maybe I'm wrong and I'm a bit biased in this, but I don't think that the EU lawmakers are really engaging in what is already there. And this is maybe this flawed law syndrome that every time we have new pieces of legislation, let's do that. Let's say that it will apply without prejudice to previous, and then it's for the court to interpret, for the court of justice maybe, or for people that are working in law firms or in academia and or in policy or in makers, maybe not, but I don't know, in regulators to understand how to solve these dilemmas. That's the point that I see, and the reason why I wanted to put this problem.
I absolutely love that point on the AI Act and DSA, especially because our listeners will remember that I wrote my dissertation in the topics. I bombed them with this, with my theory throughout 100 episodes. But before we let you go, Marco, and thank you for being so generous of your time with us. We really, really need to tell our listeners what they can do to understand a bit better this topic. And I know that you have a specific recommendation also for our Italian listeners, but also I'm sure that they will enjoy to read the article that we cited at the beginning of the podcast. That will be in the show notes. I'm sure Giacomo will take care of that. But also, yeah, tell our listeners what they can do to understand this topic better.
Yeah, it's a bit product placement moment that maybe, but I enjoy it because the I can tell you that I am frequently working on podcasts and I'm recording some of them, particularly with one of them which is named Macro and it's published by Sole 24 Ore, which is an Italian economic newspapers, of course, for Italian speaking because they are in Italians, but the article that was mentioned before by Giacomo was basically born as a report that we drafted for and prepared and published with the CER, which is the Center of Regulation in Europe. I am a research fellow at CER, and republished in the Rivista di Diritto dei Media, which is another law journal. It's in Italian, but we host many contributions also in English. An increasing number, which is also something that makes me happy because I'm also among the editors of that journal. So I think that this really reflects the internationalization that we may have. We need indeed, not just in legal studies, but also in legal research in particular in these domains. So I know that it sounds like product placements, but of course it's what I can offer, and that's where basically I tend to publish. But I know there are a lot of sources and a lot of platforms that are equally very useful. And of course, what you do is very useful as well and helpful for people to understand the real challenges ahead.
It's not product placement if the product is good, I'm told. So absolutely, everyone listen, especially if you're Italian, listen to Macro and go see that articles and maybe follow what the CER is doing because it looks like it's a very interesting and exciting project to follow through. And yes, I will thank you, Marco Bassini, Professor Marco Bassini, for joining us on the podcast today.
My pleasure. Thank you so much for your time and your attention and your questions and comments. It was a beautiful conversation.
This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.